Good morning. You may be seated. So we are here on our case number 1CACV 180530, JTF Aviation Holdings, Inc. versus CLIFTONLARSONALLEN LLP. Counsel, as you both know, you're entitled to 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record the proceedings, so we'd be grateful to you if when you approach the podium, you give us your name and the name of your client for the recording. We have read the briefs in the case. We've studied the record and the various documents attached to the filings. We've also discussed the case in our conference together. So with that, you may proceed.
Good morning, Your Honors. My name is Joe Schenk. I represent the appellants JTF Aviation Holdings, Inc. and Jeremy Freer. In this appeal, you're going to be given the opportunity to decide two issues that are matters of first impression for this court. The first issue is whether a contractual repose provision is per se unreasonable and unenforceable because of its inherent ability to result in the forfeiture of otherwise valid claims. And secondly, you'll have to decide if a non-party to a contract containing a contractual repose provision can be bound by that provision even though his claims are based in common law tort theories and are not derived from any rights as a party or third-party beneficiary to the contract. And I'm going to start out. I know that you've studied the record, but I thought I would just give a quick summary of the salient facts that we are dealing with. Prior to June 24, 2014, JTF Aviation Holdings operated a fixed-wing air ambulance service under the name Angel MedFlight. In the summer of 2013, the company's sole owner, Jeremy Freer, decided that he wanted to entertain offers to buy the company. Before he could do that, it was necessary to get some outside accounting help because the company had historically operated on a non-GAAP compliant modified accrual system. And in order to sell the company, they needed to get their financial statements into proper form. So in August of 2013, the company, JTF Aviation Holdings, hired the appellee CLIFTONLARSONALLEN, which I'm going to call CLA, to perform some accounting functions, the most principal one of which was to convert their non-compliant accounting system into a full accrual accounting system that was GAAP compliant. And so that engagement proceeded. The only parties to that agreement were CLIFTONLARSONALLEN and JTF Aviation Holdings. Mr. Freer was not a party to any of these contracts. After that work was done, in December of 2013, JTF Aviation Holdings entered into a second contract with CLIFTONLARSONALLEN. This time, the scope of that engagement was to perform an audit, the company's first audit, and to audit the now GAAP-compliant financial statements that they had previously worked on into audit financial statements that could be presented to potential buyers who might be interested in purchasing the company. Again, there was a written engagement agreement. Again, the only parties to that agreement were CLIFTONLARSONALLEN and JTF Aviation Holdings.
Well, that's the letter actually says Aviation West Charters, Inc. and affiliates. Where is affiliates defined in the engagement letter?
It wasn't, as far as I'm aware.
Where?
But
How do we
again,
know what it means?
Well, I don't really know what it means either. I think that what you're looking at is a standard engagement letter that was used by CLIFTONLARSONALLEN. They have tried to, in the trial court, they tried to portray this as a negotiated contract. Although I think the negotiations existed, they were limited to the amount to be paid for the audit and the time within which the audit would be delivered, not, the boilerplate language that really is at issue in this appeal. Be that as it may, the company, in summer of 2014, entered into an asset purchase agreement pursuant to which JTF Aviation Holdings sold substantially all of its assets to a venture capital company. The company, the agreement, the asset purchase agreement, contained a contractual representation and warranty that was signed off on not only by JTF Aviation Holdings, but also by Mr. Freer individually, in which they represented and warranted to the buyer that the financial statements, the audited financial statements prepared by CLA.
Now, so Mr. Freer made that representation personally? I couldn't see that in the APA.
He did, Your Honor. He was sued for that reason.
No, he was sued, but okay.
He did, as part of the closing documents, make that rep and warranty, and he was sued for breaching that warranty. In fact, he was a named defendant in the Delaware lawsuit, as was JTF Aviation Holdings. And I'm using that name because that's the name that they took on after the sale, because the company that bought their assets wanted to operate under the old name, and so the existing entity continued on, but it had to rename itself as JTF Aviation Holdings. And just for making this any less complicated than it might otherwise be, I've tried to just use a common name throughout for it.
So the nature of the lawsuit by the buyer against Mr. Freer and JTF was that the financials were false, and as a consequence, they overvalued the receivables and caused the buyer to pay more than the company was really worth.
Yeah, again, we're getting a little bit into the weeds, but what actually happened was there were two primary claims. One was a fraud-based claim alleging that Mr. Freer and JTF Aviation's knowingly misrepresented the financial condition and financial statements of the company when they sold it to the buyer. That one didn't have any legs because, as it turned out, there was no knowledge on the part of Mr. Freer, JTF Aviation, that there were problems with the audited financial statements at that point. But secondly, there was no reliance because the original letter of intent by the buyer was for a $100 million purchase price, but then they hired their own accounting firm, I think it was KPMG, to look at the financial statements independently, and based on their evaluation of what the EBITDA was, they based their purchase price, I think on a 5 times multiple of EBITDA, and as a result, when they finally went into the asset purchase agreement, the purchase price was reduced from the initial $100 million down to $80 million.
What was the claim that did have legs?
The claim that did have legs was on this rep and warranty that we've been discussing, wherein both the company and Mr. Freer individually made a representation and warranty that the financial statements that they had provided to the buyer as part of the transaction were both accurate and GAAP compliant. And unlike you would like to see in these contracts, this was an absolute rep and warranty. It wasn't, to the best of their information and belief. It was we represent and warrant that these are accurate financial statements.
So your argument is that JTF and Mr. Freer incurred damages as a result of that lawsuit?
That is correct. They litigated for 2 years. During the first part of the case, one of their prize witnesses were the CLA auditors who came in and gave deposition testimony that their work was, up to standard and all this. But later on, expert witnesses were hired by both sides that suggested that wasn't the case. And at that point, after spending more than $1.5 million in trying to defend the lawsuit by the buyer, JTF Aviation and Mr. Freer settled the Delaware lawsuit for approximately $5 million.
What are the damages that JTF and Mr. Freer allege in this case?
It's going to be approximately between $6.5 and $7 million. That's based on the $5 million that was paid to the buyer to settle the litigation, and the $1.5 million plus in attorney's fees and litigation costs that were spent in the Delaware lawsuit in their unsuccessful effort to defend the litigation.
So the damages that Mr. Freer alleges are the same damages that JTF alleges?
They do overlap. They cannot both recover them. The reason they overlap is that Mr. Freer was and is the sole owner of JTF Aviation Holdings, and so either if JTF Aviation Holdings, which after the sale only had cash, had $5 million less cash, or in this case $6.5 million less cash, then Mr. Freer was damaged because his asset, which is his interest in JTF Aviation, now had $6.5 million less in assets.
It's the same. It's
Yes.
the same.
It's the same pot of money.
Okay.
Now then, what I want to point out is, and get to the heart of our argument, is that in the December 2013 engagement letter between CLA and JTF Aviation, there were two items. First of all, there was a choice of law provision that specified that the parties to the agreement would apply Minnesota law to any dispute. And secondly, there was a provision which they described in the contract as a limitations provision, but it really wasn't. It was actually a repose provision. And the reason that
Counsel, the first time I see that argument is in your reply brief. Is that accurate? Did you
well,
raise
no, we
this?
actually talked about it in the sense of the accrual. We didn't use the word repose because we were arguing that it was there's a lot of argument in the opening brief as to whether or not the contract was affecting procedural or substantive rights, and we argued at that point that it was really a substantive right. In their responsive brief, they said, well, no, statutes of limitations are procedural, not substantive. So in our reply, we pointed out that, well, that may be true, but we cited case law from both Arizona and Minnesota to the effect that repose statutes, unlike limitation statutes, are substantive, not procedural. And that was held by the Arizona Supreme Court in the case that I cited.
Is the issue of whether the time limitation clause is reasonable and therefore enforceable, is that governed by Arizona law or by Minnesota law?
Well, I think that with respect certainly to JTF Aviation Holdings, it is probably governed by Minnesota law. Although we made an argument in our opening brief that it wasn't because we didn't, JTF Aviation and Freer only asserted tort claims. They didn't assert any contract claims against CLA. So the argument is, even though we had a choice of law as to disputes arising out of the contract, that wouldn't be controlling on the tort claims that we brought pursuant to common law.
But you're backing away from that now?
I'm backing away from it a little bit because, frankly, it doesn't hurt us to be in Minnesota on this issue.
Okay.
First of all,
Your best case under Minnesota law for why the clause is unreasonable?
would be the Peggy
Rose, right?
Peggy Rose case. And the Peggy Rose case is a case in which the Minnesota court pointed out the distinction between a contractual provision that simply shortened the limitations period in which you could bring a claim following its accrual, and one that messed with the accrual date. That was their specific point, was, we don't have as much of a problem saying that instead of getting, in Minnesota, by the way, the statute of limitations for the claims we've asserted is 6 years. But we don't have a problem shortening the limitations provision. In Peggy Rose, I think it was from 6 years down to 18 months. But what we do have a problem is in that case, you specify that the clock starts running upon the closing of the sale or something where, in this case, it was specified that the 24-month clock in the CLA engagement letter began to run upon the delivery of the audit, not upon, and in fact, it goes on and specifically says that it begins to run notwithstanding the fact that JTF Aviation had not suffered any damages and notwithstanding the fact that it had no knowledge of any wrongdoing or potential claim. So it was a classic repose statute. It ran from a date certain, even if there were no facts that would have allowed JTF Aviation to file a lawsuit in the first place. And that's the reason we say that under Peggy Rose and other cases that we've cited in our brief, brief, Minnesota would not permit this. The argument, in fact, the only argument that CLA has made contrary to this is that, well, in this case, because the lawsuit was filed in September of 2014, you should have just assumed that the lawsuit was meritorious and that you had a basis to assert a claim against CLA right then and there, and that would have been within the 24 months after the audit was delivered.
Now, what's wrong with that?
Well, because that is 2020 hindsight.
But you said that there was the claim that had legs. The claims that you said that had legs was that there was the breach of the.
Yeah, but my point is you're judging it with not from the circumstance of what the parties knew or understood at the time they entered into the agreement, but what they understood a year later after the fact. So when they entered into this contract, they didn't know or have any way of knowing that A, there was going to be a claim, or B, that it was going to be a claim that was not going to arise right away but sometime in the future, or that was going to arise within the 24 months. Let me take another alternate universe approach where this exact same provision is agreed to in the contract. The company doesn't sell in June of the following year, or September of the following year. It doesn't sell for a year later, and then the buyer is happy as a clam for another year before it finally figures out that there's a problem with the financial statements, so it files its lawsuit 2 years and 1 day after the audit had been delivered. In that instance, this contractual provision would effectively have precluded the customer from getting any relief on an otherwise valid malpractice claim because it couldn't have filed it before there was any damage or knowledge of a claim. And yet, by the time there was damage, the 24-month clock had run out on the proposed provision.
Peggy Rose, when we're looking at reasonableness of the period, we're looking at the facts as actually presented, not this hypothetical, which is not this case. In this case, as Judge Brown pointed out, there was a claim with legs, your words, within the 24-month period, isn't that?
That is true, but again, I'm saying you have to look at, that's the problem between a contractual limitations provision and a contractual repose provision, because on a limitations provision, going in that, hey, I'm always going to have whatever amount of time, even if it's just 6 months after I'm damaged or after the claim is accrued, so I have to act quickly and I can get on it. But in this instance, we could not, if we had not been sued when we were, under this provision, we could have never sued for a valid claim for malpractice because the time would have lapsed under this provision before the cause of action ever occurred. Well, and that's the downside. And we don't know when we enter into these agreements how the world's going to turn out. So basically you have to say, are you going to allow the enforcement of contracts based on 2020 hindsight, or are you going to allow them on the basis of what the contract contemplates? This contract, by having a fixed date for the starting of the clock, anticipated that there would be situations where otherwise valid claims were going to be forfeited because they couldn't be asserted until after the time ran out. And I would say that a Minnesota court would find that is unreasonable and unenforceable as a matter of law. And I think that if you look at the Peggy Rose case and the logic they're using in their analysis, as I said, this is a case of first impression, but it's one that I think follows from the Peggy Rose decision. Now, I got very little time to talk about Jeremy Freer, and I just want to say there has been no case law cited by the trial court, by opposing counsel, by anyone. I have not found any, and I've researched the dickens out of this, of any case that has held that a non-party to a contract is barred from asserting tort claims that are not derived from the contract because of contractual provisions in the contract that he was not a party to. The cases that were cited in the response brief were all third-party beneficiary type claims where a non-party was asserting claims as a third-party beneficiary. That's not what we have here. We have a situation where Jeremy Freer is asserting a negligent misrepresentation claim based on the standard chartered authority. And I'm going to reserve my last minute.
Thank you.
Good morning, Your Honors. Charles Jones from Moss & Barnett in Minneapolis on behalf of CLIFTONLARSONALLEN, and I thank you for letting me come down to your stand and present some more argument here. So, thank you.
March.
I'm sorry?
In March.
In March. Well, it's going to be 60 degrees in Minnesota today, so we're excited. But I want to just talk here a little bit about a few issues in terms of our request that you affirm the Superior Court ruling granting my client's summary judgment. And as we see it, there are three basic issues. The first issue is the choice of law provision enforceable? And I think we heard a concession that it's enforceable as to the company, but as to Mr. Freer, I have more to say about that. The second issue is the contractual limitations, and I use that word advisedly, clause enforceable. And the third issue is Mr. Freer, Jeremy T. Freer of JTF Company, is he bound by the contractual limitations and choice of law clauses at issue in this case? And I want to just begin here. I don't really have any terrible disputes with the presentation of facts that we've heard already from Mr. Schenk. Just a couple points I wanted to emphasize. I think it was undisputed before the Superior Court, excuse me, that in the negotiation of the engagement agreements, JTF was represented by counsel and that there was an opportunity to negotiate those. The choice of law and contractual limitations clauses, it's undisputed in the record, are something that CLA does negotiate from time to time. And so whatever percentage of the case here is based upon the presentation that this is some sort of adherence contract or something like that, I don't think has any support in their record. These are bargain for clauses.
What does the record tell us about why Mr. Freer looked to a Minnesota accounting firm?
I don't know that there was specific back and forth on the clause. I'm not trying to say that, Your Honor.
I mean, just how this relationship began. Does the record tell us anything about that?
Well, what we do know is that, let me make sure I understand your question.
Did the company operate in Minnesota?
JTF, no. CLA's headquarters are Minnesota. And there was what's the word I'm looking for here, a process by which JTF was putting out bids for various auditing firms, and CLA responded.
Okay.
And we do have a Phoenix office, yes. Okay. And I think it's very important, a fact which came out and was discussed at some length here a few moments ago, was the fact that Mr. Freer, his involvement in the transaction, it's his company, he's the sole shareholder. As was discussed, he made the warranty concerning the gap compliance of the financial statements which underlie the lawsuit.
Where is that to be found in the asset purchase agreement?
The way I get there, Your Honor, is I look at the asset purchase agreement, which is among the parties, including Mr. Freer himself, and the parties make the warranty.
Well, he's not defined among the seller, though.
I could get to the whole agreement, but I start with the definition of parties at the beginning, is where I get that.
Okay. All right.
I don't know that we briefed that in any particular detail, specifically as to how we got there. But what does happen is that a very short period of time after the asset purchase agreement goes through, Vistria starts to say, wait a minute, there's a problem here, and the lawsuit is commenced just about 3 months. In fact, I think even less than 3 months after the asset purchase agreement is signed. And during that time, the CLA records were subpoenaed. There was an opportunity. Yeah, the CLA did defend its work, sure it did. But the records were subpoenaed, the work papers were subpoenaed, and certainly was on notice from the beginning of the lawsuit in September of 2014 that at least the buyer thought that there was a real problem with the audit and the financial statements of JTF. So the first issue that arises out of all this is the choice of law clause. And again, I'm going to skip over that a little bit. I had more argument prepared on that point, but I think in view of what we heard this morning, I'll skip past that point a little bit. Just to say, we do look at the actual language of the clause. Here it's any dispute, not just the contract, but any dispute, and that's what we have here. So I want to focus, I think, then, I'll move on to the contractual limitations clause. And it is a limitations clause. And I think the gist of the argument that we heard here this morning was that a Minnesota court would not enforce this clause. And I hope I'm being fair to Mr. Schenk, but that's the gist of the argument that I heard. And the short answer is yes. The Peggy Rose case, as Judge Perkins pointed out, under that presentation or under that case, we deal with the actual facts of the situation. So what are the actual facts here? By September of 2014, there's a clear indication to JTF that it's got financials that are being challenged, at least by the buyer. It has to hire a lawyer. It has to defend that case. And under that rubric, under that situation, that's clear damage under Minnesota. What Minnesota has, we have a 6-year statute by statute, but we have an accrual rule, which is very consistent with the language of this particular contractual limitations clause. We have the sum damage rule, and under the case law in Minnesota, the Antone versus Mervis case, the Ames and Fisher case, the recent case, Frederick versus Wallerick, the Veit versus ProSource case, and a host of other cases, the claim accrues at the moment the plaintiff is damaged by the negligence of the defendant, the professional defendant. And under the Veit case, which I think is very germane, the plaintiff in that case was damaged at the moment it received a deficient real estate appraisal report. That was the damage right there. So here, the theory of this case is February 3rd, 2014, the audit is sent to the shareholder of JTF, Mr. Freer himself. At that point, under Minnesota law, there is damage, whether or not Mr. Freer is aware of it.
Is it knew or should have known? Is that essentially the concept? That you either knew or you should have known?
It's not even that. It's just, you're just damaged. In the Antone versus Mervis case, the plaintiff signed a prenuptial agreement that did not adequately protect his rights in the appreciation of property that occurred after marriage. So once he got married, his interest was mingled with his wife's. I forget how many years the two were married, but it was many years. And then they finally got divorced, and the Supreme Court said, nope, at the moment you got married in reliance upon the negligently drafted prenuptial, that's when your damage occurred, at that moment, whether you were aware of it or not. I suppose with the exercise of some diligence, he could have found some other lawyer who could have told him at that point that there was a problem, but it's not even a knew or should have known standard. He was damaged at that moment. And the dissent points out this is the only time that we've ever held that marriage is an act of damage, but that's that's for somebody else to decide, I suppose. But that's the rule in Minnesota, and that's what this particular clause says. And as we've had some discussion here this morning, there is, regardless of the nebulous damage, I don't know if I want to say nebulous, but the damage resulted by having an allegedly faulty report on February 3rd, there is concrete for sure damage on September 20th, 2014, or it's 25th, whatever the date is, when Vistria starts the lawsuit. And, a lawyer signs a complaint under Rule 11 saying your audit report that we relied upon in this purchase was invalid.
Under Minnesota law, could JTF and Mr. Freer, immediately upon having been sued by the buyer, filed a third-party complaint against Clifton for essentially indemnification?
I think that claim existed. I would say that the claim against CLA for a negligently prepared audit report existed on February 4th of 2014. We're not conceding that it's valid, of course, but that claim would exist under their theory. And certainly, by the time that Vistria starts the lawsuit, there's an opportunity for JTF to have said, and Mr. Freer to have said, hey, we think the problem here is CLA's fault. We better deal with that. Sure. Mm-hmm.
So that claim would not have been subject to a motion to dismiss for, under Minnesota law, for failure to actually show that, yes, I have been damaged.
Yeah.
Proof of damage.
And Your Honor is exactly iterating the standard under Minnesota law. That is, when a claim accrues is when the plaintiff can allege the facts necessary to state a claim under Rule 12. Mm-hmm. And that could have been alleged at that point, for sure. And so the Peggy Rose case, which was discussed a little bit, really has nothing to do with this scenario because there we're dealing with a scenario for the accrual of an intentional fraud claim, which is not what we have here. We have a negligent misrepresentation claim, certainly, but we don't have an intentional fraud claim, which under Minnesota law is a different standard. So there, the problem in Peggy Rose was that the 18-month period went by before the fraud accrual standard could ever have come into play. So that's a completely different situation than what we have here.
Okay.
Okay. Looks like you had a question, so I was waiting there. So I think that covers the points I wanted to make about the limitations clause. But if you had any more questions, I'd dive into my third point.
But tell us, I guess I did have a question. Tell us about the Minnesota law applying to when a claim for fraud accrues.
Well, that is a newer or should have known standard, as Judge Brown was asking. And so under the Peggy Rose case, the problem is that the plaintiff had no knowledge whatsoever of the facts underlying the fraud claim during that 18-month period of the contractual limitations clause.
So in evaluating whether a limitations or repose is a provision is reasonable under Minnesota law, you need to look to what, absent that, what Minnesota law would do with the claim, and so assess the reasonableness against that outcome for the particular claim by claim.
Look at the actual facts of the situation. Does the clause at issue give the plaintiff enough time to sit back and say, wait a minute, do I have a case here?
Okay.
And that under these facts, I'm not talking about any other facts that may have existed anywhere else. Under these facts, that opportunity did exist.
So, counsel, on Peggy Rose, are you saying it's your opinion that it's limited to intentional fraud claims, the Peggy Rose case?
That's why.
Or is our cases that have said that case is limited to intentional torts?
The jurisdiction is you look at the actual facts of the case. Okay, does the clause at issue give the plaintiff enough time to assess the claim? The problem in Peggy Rose is it did not, because under that case, the claim at issue was an intentional fraud claim, which had not even accrued at the time the limitations period expired. That's the best answer I can give to that. But again, you looked at I don't think there's a broad rule I'm not trying to say that Peggy Rose would say there's a broad rule that our clause would only apply to certain kinds of claims. I think the broad rule is, does the clause at issue give the plaintiff enough time to sit back and say, do we have a case here? That's the only broad rule that I take from Peggy Rose. As the court says in Peggy Rose, what is acceptable in one case may be objectionable in another. I mean, I think that's pretty much a direct quote from the case. So I think the big issue here, and as Judge Johnson, you pointed out in one of your questions, was what are the different damages that are being asserted? It's the same bucket of damages, right? It's a question of who gets what damages. And that, I think, is very germane to the third point, which is Mr. Freer now personally bound by these two clauses? And we cited a number of cases which support our position on this, and I'll just get it right out front. Is there an Arizona case which says that he is bound by it? No, there is not an Arizona case which says that directly.
Is it Arizona law that applies?
I think Minnesota law applies to this question, right? Because we have a choice of law clause. But I don't want to, Judge Brown is giving me a look, and the question is,
it's like, where's your authority? Yeah,
how do I bootstrap
is
there?
this the chicken and egg, which came first?
Right. Bootstrap, chicken and egg, however you want to describe it. Sure. The point is I am saying that Mr. Freer is bound by the choice of law clause. How do you get there? Maybe Arizona law governs that question. Is there an Arizona case directly in point? No, there is not. I agree with Mr. Schenk on that point. This is a matter of first impression for this court. I don't think there's any dispute about that.
Okay, what should we look to then?
I think we should look to the cases that I've cited, which there's a couple of different theories here, right? There's the direct benefits estoppel theory, which when you accept the benefits of a contract, then you are precluded from challenging the other parts of the contract that you don't like. And I don't think that's the way the courts describe that theory, but I think that's a fair summation of it. And there's a lot of rhetorical hand-waving going on in Mr. Freer's argument on this point. He's saying our claim doesn't arise from the contract. Well, it does. Absent this audit agreement, this engagement agreement, there is no audit. If you look at the complaint is all about plaintiffs this, plaintiffs that, engagement agreement, CLA agreed to do the audit. The audit is the obligations about the audit are set forth in the engagement agreement. Mr. Freer takes that audit, makes a warranty, uses it to support the sale of his company. It's undisputed that before the Vistria, now I can't even see my time, before the Vistria transaction goes through, everybody knows that the audit is going to be used to support that sale. It's, I think, no possible conclusion from the record other than he is suing based upon the relationship created by the engagement letter containing these clauses. That's the whole ballgame right there.
Okay, so put that in a more broad statement. What's the test? And let me ask you this question. How close does a party have to be close enough? I mean, this seems like a really fuzzy area.
I agree with that, Your Honor. And I actually spent time thinking about that on the plane last night and this morning in my hotel room. And I don't have a bright line test for you. If we look at the Standard Chartered Bank case, which is cited by Mr. Freer for the proposition that we can't impair my substantive rights. Our first point is we're not impairing your substantive rights. We're saying you just sued too late procedurally. Would the bank and Standard Chartered be close enough to this to the contract to sue? I don't think so. How does a bank accept benefits the way Mr. Freer did?
Well, that was a buyer, too. That wasn't a seller.
Correct.
Right.
Thank you, Your Honor. Yes, thank you. And so I think it is a little bit of a fact-by-fact scenario, and we have a pretty well-reasoned decision from the Superior Court saying under these facts, and I think the judge does go out of his way to say under these particular facts, where again you have the sole shareholder of the company. He's basically the only beneficiary of the sale to Vistria, right, because he is the sole shareholder. He's using it in terms of supporting the sale. Under these facts, it's enough to say that he's accepted enough benefit of the contract to say that he can't brush off those parts of the contract he doesn't like.
And the claim, the key claim, as I understand it, we're being told by the buyer against Mr. Freer is that he breached a warranty as to the validity of the financials. And that was a warranty that we are told he made based on the financials that Clifton provided.
I think that's a fair summation of the underlying case. Yeah. So it's a situation where in these particular circumstances, Mr. Freer is a person who is subject to this direct benefits estoppel argument that's supported by the, and I never know how to say this word. Is it Hellenic or Hellenic? I'm never sure how to say that word. The Hellenic Fund case. The direct benefits estoppel is a doctrine that's recognized in Arizona in general. To this specific point, I don't think it's been applied to the specific point, but it is a doctrine that has support in Arizona law, and we cited those cases.
Does that overlap with the closely related party theory?
Yeah, I think it does overlap. Analytically, I think there's a lot of overlap there. I think it sort of boils down to the same point. Is somebody close enough to the contract that they can't, again, brush off the points they don't like? A key factor under the closely related party analysis, and those are the Minnesota cases, the Morano case and the C.H. Robinson case. A key point under those cases is do the parties join together in a lawsuit concerning the enforcement of the contract or dealing with the contract? And in fact, in the Medtronic case, which is a case we cited, that's a case where Judge Thunheim said that I'm not going to apply closely related because here they didn't join together in the lawsuit. But here we do have Mr. Freer and his company joining together in the lawsuit and asserting a claim based upon this relationship created by this contract. So I think we are squarely within the ambit of that doctrine as well. So, in conclusion, Your Honors, I'm down less than a minute here, so I'll just get to my point here. We do ask that you affirm the Superior Court's summary judgment and be glad to answer any other questions you might have. And I thank you for your time.
Thank you.
Excuse me, Joe.
Again, Joe Shank, on behalf of the appellant's going to have to talk quickly. First of all, with regard to the suggestion that the provision in the contract, parallels the accrual of claims under Minnesota law. Minnesota is a damage accrual state, meaning that the claim accrues when there's some damage has been suffered. If you look at the provision in this contract you're being asked to enforce, it states that the limitations period applies and begins to run even if you have not suffered any damage or loss or have not become aware of the existence or possible existence of a dispute. So there is no equivalency between this provision and Minnesota law, because this starts to run under the contract even before there's any damage. So you always have the possibility of forfeiture where you don't get sued, you don't incur any damages because of the negligent financial statements until after the 24 months is run. So that's the first point. The second point, with regard to Jeremy Freer's responsibility, I would cite the court to the whole line of cases in Arizona that say that professional malpractice claims do not arise out of contract for purposes of attorney's fees, and I would specifically cite you the Lewin v. Miller-Wagner case at 151 Arizona 29, page 36, where the court stated, quote, "We therefore conclude that while a contractual relationship may give rise to a duty to perform in accordance with a certain standard of care, this legally imposed duty exists separate and apart from the contract giving rise to the duty. The failure to comply with this standard of care results in a breach of the legal duty imposed. It is not an action arising out of contract." That's a quotation from that case. So Arizona pretty clearly can distinguish between a contract putting someone within tortious striking range and creating a duty which creates the cause of action. In this case, Jeremy Freer's claim was stated under Arizona common law. It was not derived from the contract, and is certainly not a claim that arises out of that contract. So therefore, he should not be held bound by a contract to which he was not a party, because he was not claiming a benefit under it.
Okay, thank you. Thank you to both of you for your argument and for all of you for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll adjourn.